Good day, Crime Talk aficionados. We come to you from on the road, and we have a great show for you today. First, what is next in the Bryan Kohberger matter? Luigi The Musical. We have a Karen Reed update. Donna Adelson asked for another continuance. This day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and you can check us out on any of your favorite podcasting apps. Before we get to the docket, though, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire on anyone in the United States. You go to the site, you type in a name, a report is generated, and it is sent to you almost immediately, and you can get updates if the information is updated. And you're going to get all kinds of information about the person you're searching about. First, phone numbers associated with them, emails. You're going to find out their social media presence. Are they married? Are they divorced? Do they have liens, judgments, a criminal history? Are they on one of those sex offender registries? Yes, everything you want to know about somebody, they're maybe not going to disclose to you. So go check them out. CrimeTalkSearch.com. You're going to be happy that you did. All right, ladies and gentlemen, it is May 1st, 2025. As you can tell, we are on the road. We are down here in the Florida Keys for a wedding. Absolutely amazing. It's a private club. I'm not going to release the name, but it is amazing to say the least. We still have a great show for you today. And first, on the docket, let's go ahead and open the record. What is next in the Bryan Kohberger matter? Now, obviously, if you watched the show yesterday, you know that the judge issued a pretty scathing response to the defense. Now, the defense has one goal here, ladies and gentlemen, and I tell you this from the experience of a criminal defense attorney. Now, I've only done one death penalty case in my 30 years, and that's probably a good thing. But the reality of it is most death penalty cases are death penalty because the evidence is usually overwhelming. I think I can think of one occasion that I'm aware of where somebody is charged with a death penalty and then basically they walk on the first-degree murder. The case that I'm thinking about, the person was convicted of second-degree murder, and well, they filed habitual criminal charges against him, so he still got 96 years. So normally the goal of a defense attorney when it comes to a death case is to take death off the table. And the defense attorneys for Bryan Kohberger have done everything they could up to this point to try and do so. Obviously, the prosecution is not buying what they are selling. They aren't going along with the whole argument that because he has autism spectrum disorder level 1, that somehow he should be taken off of the death row eligibility, so to speak. And everything else that they have submitted or asked for, nothing has been able to break the prosecution and say, fine, uncle, let's just go for life without the possibility of parole. Now, there's talk that Bryan Kohberger is quite adamant that he thinks he's going to be acquitted at trial. And apparently, according to the scuttlebutt, so does his mother, and his mother doesn't want him to even consider taking a plea deal. Now, that's interesting. I get it. Mothers, they're always going to be there for their little baby. I get that. But sometimes you have to look at this objectively and say, hey, there's a lot of evidence against you. And I know a lot of people will say Bryan Kohberger is entitled to the presumption of innocence because he has not been convicted yet by a jury of his peers, nor has he pled guilty. But the reality of it is you have to look at the evidence. And we know everything that is quite damning, the defense attorneys have tried to make it go away. First, the death penalty, that didn't work. Then they tried to make the whole case go away by saying somehow the DNA evidence was obtained illegally. That didn't work. Then they tried to file motions in limine to keep out all the bad evidence, right? The purchases from Amazon, the phone record information, everything that is bad for them. And I'm telling you, as a defense attorney, his defense attorneys will look at this and saying, this is bad. And we don't have enough to overcome this. But now, ladies and gentlemen, basically the motions practice is done. Now, there will be motions that'll straggle in. But at this point, we're 4 months out. The prosecution has turned over their witness list. They've turned over their exhibit list. for all intents and purposes, the prosecution is ready to go to trial. So what is next? Either one, Bryan Kohberger needs to tell his attorneys, I will take life without the possibility of parole, probably plead guilty to all charges, in the event that he would then get life without parole, take the death penalty off the table. I'm not even sure the prosecution would do that at this point, but maybe. They would probably have to go talk to the victim's family and see what their position would be. One thing that would be good for that is obviously there's resolution, because if there's not a guilty plea, then it goes to trial. And then this will be, if there's, assuming there's a conviction and there's a death penalty imposed, which no guarantee that one will be imposed, because guess what? Although legally, what the defense is arguing about the autism spectrum disorder and that he's a good guy and never been in trouble, all those things, a jury may say, well, maybe that's enough to spare his life. But if they do impose the ultimate penalty, guess what? It will be in litigation for the next 30 years. And there'll be post-conviction motions saying the attorneys weren't prepared, they didn't do anything right. And we already see defense attorneys already kind of throwing themselves on that sword by saying that, well, you know, there's so much stuff, I can't review it all by myself. I'm probably going to be ineffective in denying my client's Sixth Amendment effective assistance to counsel. Now we'll have to wait and see. But as we brought you yesterday, the judge issued a damning order to Bryan Kohberger and his team, and basically saying, yeah, you could still potentially face a firing squad if you were convicted of the brutal stabbing murders of the 4 University of Idaho students. Now, in the court order that was issued just the other day, and we went through it last night for you as well, Judge Hippler completely struck down his latest attempt to basically say the prosecution failed to hand over evidence in a timely and accessible manner. And they said that, frankly, their complaints are hollow. Defendant complains of being unable to meaningfully review the discovery rings hollow, exactly what the judge said. And the defendant has received literally all the discovery in the same manner as the prosecution has for over 2 years. And probably the biggest jab that the court took at the defense team was that there was no misconduct by the prosecutors that they can identify at this point. And then the judge says the defendant cannot demand everything under the sun and then complain about the weight of the planets. So he pretty much scolded the defense. You can't have your cake and eat it too. You want all this discovery. You think everything is relevant. You're looking for everything that's exculpatory. And then don't come to us when you haven't had sufficient time to review it. And the prosecution hasn't specifically identified what you think is exculpatory. The prosecution says you have everything we have, and we are not aware of anything that's exculpatory for the defense. And we've identified everything that we're going to use here at trial. So get over it. So like I said, decisions have to be made. That is the point here that we're coming up. Motions practice is all but done. And unless the defense can come up with a credible alternate suspect, well, this bad boy is going to be tried at trial, and we're going to have to see what a jury decides. Now, I would think that a reasonable juror could easily find that Bryan Kohberger committed these crimes. Now, the question is, will there be enough by the defense to raise reasonable doubt? Not a vague, imaginary, or speculative doubt, but a doubt that would actually cause people to pause in matters of great importance. And now, whether you think the roommates acted oddly or anything along those lines, guess what? It doesn't take away any of the evidence as it relates to Bryan Kohberger and his alleged involvement in these quadruple homicides. So I've said this before and I'll say it again. Hey, I'm a defense guy, right? I'm rooting for the defense. I always am. But you have to be realistic. You have to be able to look at the evidence objectively and remove yourself from the emotion of the battle and say, look, we've got problems. What can we do to avoid the situation here of ultimately having the ultimate sentence imposed of death? Next on the docket, guess what? Luigi The Musical. Who would have thought? That's right. From the killer barber of Sweeney Todd to Stephen Sondheim's Assassin, musicals have long dealt with morbid subjects indeed. But now a musical based upon Luigi Mangione, right? The 26-year-old accused of gunning down a CEO of a healthcare company in cold blood, is on its way to the stage in San Francisco. That's right, Luigi the Musical, billed as a story of love, murder, and hash browns, is due to open in June at the Taylor Street Theater, formerly the Exit Theater. The show is described as wildly irreverent, razor-sharp comedy that imagines the true story of Luigi Mangione, like I said, the alleged corporate assassin turned accidental folk hero. It will also feature other famous characters, including convicted crypto fraudster Sam Bankman-Fried and former rap mogul turned alleged accused sex trafficker Sean Diddy Combs. The show is directed by Nova Bradford and features original music and lyrics by Ariel Johnson. Johnson Bradford and a co-writer by the name of Caleb Zering are all involved in the local San Francisco comedy scene. Apparently, Mangione will be portrayed by Petmala, based upon an actor and comic, Johnny Stein, who admittedly bears some resemblance to the accused murderer. The 60-minute show will make its debut on Friday, June 13th, and is currently scheduled for 5 performances. I think I will hold off on getting my tickets for that. We'll see what takes place. But obviously, you know, throughout history, there's always been famous people accused of crime. But now I guess it's a time where if you're accused of a crime, that's right, you become famous. Who would have thought? Next, a quick update on the Karen Read trial. Day 7. The Commonwealth second witness, Jennifer McCabe, returned to the witness stand for a second day. Defense attorney Alan Jackson questioned McCabe about whether she and Carrie Roberts discussed their testimony, to which she said that they only talked about sharing their experiences testifying and never about their testimony. Jackson questioned whether McCabe called Roberts to ensure their stories lined up. McCabe said that she and Roberts are just normal moms. They have never been through anything like this. We both know what happened. We don't have a story. There is no story. We were there. That's it. Now, Jackson pressed McCabe on whether she was being truthful to officers from an outside law enforcement agency, questioned her in this case. McCabe told them that between the time she arrived home and when she spoke with them, she called the 2 people, her husband, Matt, and Carrie Roberts. She, however, admitted to calling 3 additional people, John O'Keefe's mother, her brother-in-law, and her witness advocate with the district attorney's office. McCabe said that she had forgotten who she called and contends that she did not lie to the officers at all. When questioned on cross-examination whether she heard a collision or any scream for help outside her sister's home, Jennifer McCabe said no. McCabe said that she did not see John O'Keefe lying in the yard when she left the house an hour later. Now, McCabe was questioned about whether she told the grand jury that Karen Read said, quote, I hit him, end quote, at the scene. She said that she was unsure, but added, I have testified a number of times, but I was there the morning of January 29th when your client said, I hit him. You know, the case goes on for the defense, and, you know, McCabe is somewhat of an important witness for the defense. Frankly, I think she held her own for the portions that I have seen, which is nearly all of it. Did the defense score a couple of points? Maybe. Is it enough to say, wow, she's a complete liar? But remember, the jury will receive a jury instruction that says you can believe some, part, or none of a witness's testimony. And that happens quite frequently. This is a high-profile case. She's talked to people. Unless they have some rebuttal witness to say, isn't it so? You said you lied on the witness stand. You made this whole thing up. The jury's going to have to decide whether she is testifying truthfully as to what she heard or didn't hear. The reality of it is, Karen Read, we've heard from her own statements, that she made on interviews questioning whether she had actually hit him. So that is basically corroborated. McCabe's testimony is corroborated by Karen Read herself. So we'll see how it goes. We still got a long way to go. We'll have to wait and see. Next, an update on the Donna Adelson matter. She wants a continuance. Ladies and gentlemen, Donna Adelson, if you don't recall her, she is charged with first-degree murder, conspiracy, and solicitation in relationship to the 2014 death of her ex-son-in-law, Dan Markle. Now, she has pled not guilty. Once again, she's entitled to the presumption of innocence. And well, she had court the other day, and her defense team is asking for a delay in her upcoming trial, which is supposed to begin on June 3rd. Now, the defense is seeking a continuance because they say they need more time to review new discovery that they obtained in the form of wiretaps and over 80,000 emails. They also told the judge that they are waiting on discovery that they're entitled to under the rules governing jailhouse informants that they have not yet received. This includes whether anyone who has given favorable treatment in exchange for testimony, as well as statements that the prosecution intends to elicit. Now, for those who don't recall this particular case, Markle was a law professor at Florida State University and was gunned down in his garage, which was eventually revealed a murder for hire plot. Adelson's son, Charlie Adelson, was convicted of hiring 2 hitmen to carry out the killing, and Charlie is currently serving life without the possibility of parole, and so is one of the hitmen in the case. The other hitman took a plea deal. An ex-girlfriend of Charlie, who served as the liaison between the Adelsons and the hitman, is also serving life without the possibility of parole. And Donna was arrested 1 week after Charlie's conviction back in November of 2023. As you may recall, she was literally on the plane where, the extradition isn't so great. Needless to say, the courts found that she is a flight risk and she is not going to get a bond. Now, yes, the defense is completely entitled to all of this information, but once again, 80,000 emails. The defense has to move more expeditiously to get this stuff done. The prosecution may want a continuance just as bad as the defense, and the defense may be entitled to this. We'll let you know when the judge makes his decision on the motion to continue. Next on the docket, this day in legal history. On May 1st, 1847, Michigan becomes the first state to abolish the death penalty for all crimes except treason, a pioneering criminal justice reform move. On May 1st, 1920, prohibition enforcement intensifies with federal raids on illegal distilleries in New York, highlighting organized crime. On this date in 1931, the Empire State Building opens, prompting legal updates to building safety codes after construction accidents expose huge regulatory gaps. On this date, May 1st, 1951, the 22nd Amendment, which limits presidential terms, takes effect, a legal response to Franklin Delano Roosevelt having 4 terms as president. And on this date in 1958, President Eisenhower proclaims May 1st as Law Day, celebrating the rule of law codified in 1961 by Congress to counterbalance Labor Day. And on this date in 1970, the Racketeering, Influence, and Corrupt Organization Act, known as RICO, their implementation begins, and it revolutionizes organized crime prosecutions. And on May 1st, 2011, Osama bin Laden is killed by U.S. forces, raising legal questions about the extraterritorial military actions and international law. I'm okay with whatever they did on that one. Osama bin Laden, bad guy. And then finally, our dumb criminal of the day. Just when you think we can't find any more dumb criminal contestants, guess what? They are always there. And since we're in Florida, well, let's have a Florida dumb criminal. An 87-year-old Florida man was arrested for domestic battery after tangling with his wife when she sought to turn the air conditioning down in the couple's residence. Don't mess with a man's thermostat, ladies. Apparently, this had been quite an issue for the couple. When the thermostat triggered a 7 a.m. confrontation between Charles Ingram and his 85-year-old wife. Now, investigators say that Ingram returned to the couple's St. Petersburg home and argued with the victim, his wife, about the air conditioning. The woman touched the thermostat to turn down the air, prompting Ingram to allegedly push the victim away from the thermostat and against the wall. When questioned by police, Mr. Ingram reportedly admitted to pushing her first and then stated that the victim pushed him back. Well, Mr. Ingram obviously was arrested for domestic violence. Charge was enhanced due to a prior battery conviction that dated back more than 4 decades. Mr. Ingram is scheduled to appear in court on Thursday afternoon. A judge will more than likely order that he have no contact with his wife, which means he can't go home. And guess what? That means she gets to control the thermostat. Mr. Ingram, I sympathize with you. Don't touch the thermostat. You can't push anybody against a wall if they do. You, sir, are our dumb criminal of the day. Congratulations. All right, that's all we have for you today on the road. Hope you enjoyed the show. Have a wonderful day. We'll see you next time on Crime Talk. And remember, the Constitution matters.